This module explored the many ways real property can be owned, transferred, and managed under Arizona law, focusing on how ownership structure affects control, inheritance, taxation, and probate. Understanding these distinctions is essential for real estate professionals, as ownership type not only determines who holds title, but also dictates what happens to property upon death, divorce, or sale. Arizona recognizes several forms of ownership, each with unique legal implications. Sole and separate property, community property with right of survivorship, joint tenancy with right of survivorship, and tenancy in common. Sole and separate property applies when an individual owns property independently, usually acquired before marriage or received through inheritance or gift during marriage. Under ARS, paragraph 25-213, it remains separate so long as it is not commingled with community assets. For example, if a spouse purchases property before marriage and keeps it titled solely in their name, that property stays separate unless both spouses intentionally change title or mix funds. Community property, defined under ARS, paragraph 25-11, encompasses assets acquired during marriage by either spouse, except by gift or inheritance. Both spouses own an undivided one-half interest, meaning neither can sell or encumber the property without the other's consent. This ensures fairness and equality in marital ownership, but requires joint participation in all transactions. To combine the benefits of equal ownership and automatic inheritance, Arizona allows community property with right of survivorship, CPW ROS, under ARS. Paragraph 33-31. Upon the death of one spouse, the surviving spouse automatically becomes the sole owner, bypassing probate. CPWROS also provides a double step-up in basis for tax purposes, which can significantly reduce capital gains taxes upon sale. Joint tenancy with right of survivorship, JTWROS, functions similarly but is not limited to married couples. Two or more parties hold equal ownership, and when one dies, their interest automatically transfers to the surviving owners. This form of ownership must include explicit survivorship language on the deed, as omission defaults the ownership to a tenancy in common, where each owner's share passes through their estate upon death, often requiring probate. A tenancy in common allows multiple parties to hold unequal ownership shares, such as business partners or investors, but it lacks survivorship rights. When one owner dies, their share becomes part of their probate estate and transfers according to their will or state law. The module also examined the difference between community property and sole and separate property, particularly regarding acquisition before and during marriage. Property obtained before marriage or by inheritance remains separate, while assets acquired during marriage are presumed community unless proven otherwise, if both spouses contribute to the property's upkeep or mortgage. Even separate property can become partially community through commingling. An important legal issue arises when only one spouse signs a purchase or sale contract for property held as community property. Under ARS, paragraph 25-14C, both spouses must consent to convey, encumber, or sell community real estate. A contract signed by only one spouse is voidable. It cannot bind the other spouse or transfer full title. Case law such as Rodiek v. Rodiek, 1955, and Rundle v. Winters, 1958, confirms that both spouses must sign for a valid conveyance, protecting marital property from unilateral decisions. The module also introduced the beneficiary deed, authorized under ARS, paragraph 33-405, which allows an owner to name beneficiaries who automatically inherit the property upon death without probate. The owner retains full control during their lifetime, with the right to revoke or sell the property at any time. The deed must be recorded before death to be valid. If the property is community property, both spouses must sign. Otherwise, only the signing spouse's half transfers upon death. To avoid probate, Arizona provides several ownership structures that allow automatic transfer of title upon death. These include joint tenancy with right of survivorship, community property with right of survivorship, and beneficiary deeds. Each allows title to pass by operation of law, eliminating the need for court involvement. As reinforced in Re Estate of Estelle, 1980, the language on the deed determines whether survivorship rights apply. However, when property is titled solely in the decedent's name or lacks a survivorship or beneficiary designation, probate becomes necessary. Only a court-appointed personal representative, authorized by letters testamentary or letters of administration, has legal standing to list, sell, or transfer such property. Family members, heirs, or divorcees have no authority until formally appointed under ARS, paragraph 14.3203, and paragraph 14.3701 through paragraph 14R3715. The case in Re Estate of Newman, 1991, established that a property sale agreement signed by an unauthorized individual is unenforceable. Finally, the module explained the common causes that trigger probate. Probate is required when property is titled solely in the decedent's name, with no survivorship clause or beneficiary deed. A beneficiary deed was signed but never recorded. The property was held as tenancy in common. The decedent died without a valid will, intestate. There are disputes or title defects requiring court clarification. The property is located in Arizona, but the decedent lived in another state. Ancillary probate. Under ARS, Title 14, probate ensures debts are paid, rightful heirs are identified, and clear title is established. While it serves an important purpose, probate can be avoided through careful estate planning and proper ownership designations. In summary, ownership type determines control, transfer, and tax treatment of real property. Community property requires mutual consent for transactions, while sole ownership allows independent action. Joint tenancy, CPWROS, and beneficiary deeds allow automatic transfer upon death, avoiding probate. Probate is required when no survivorship or beneficiary designation exists, or when property ownership is unclear. Only a court-appointed personal representative has standing to act on behalf of a probate estate. By understanding these principles, Arizona real estate professionals can better guide clients in choosing ownership methods that align with their personal and financial goals, while avoiding costly legal complications in the future.